if that file was open partial to those orders, then it should be a file containing those other files. Probably you can give us directions, my lady.
Okay, maybe just for transparency, I wish to inform Council that the matters that are attached to this file is petition 003 of 2024, Commercial and Tax Division. I guess this is Nairobi, but formerly Machakos High Court petition. Number is 006 of 2024, and same Machakos petition 003 of 2024. So, pursuant to that, just a moment, Mr. Ogim. And lastly, what I can see before me is KISI E003 of 2024. Those are the files that I have. Then there is Constitutional and Human Rights Division petition number E159 of 2024. Vincent Marita Omao versus Senate and 6 others. Those are the files that are before me. Yes. So now you can.
Thank you.
Just before, my name is Kemuto. Our file was E010, so wait, E007 of Machakos, which became E010 of Nairobi, which is our purity killer. The file was transferred by Justice Ogola on 10. I don't know if the same.
That one is not before me. I don't seem to have that one. Yes.
Yes, Melody, with your kind permission, just to move forward in an orderly manner,
yes.
My proposal would be, let us go with the files you have, and the way we've started, the way you've already mentioned this first petition, let us deal with it. And I say so because most of us are not parties in this file. We have pending applications, so that the other question would be whether we even still have audience to address the court on that file on substantive issues. Then number 2, my lady, we are aware that there is a notice to withdraw that particular petition, and then the impending issue of representation. So that for orderly purposes,
a notice to withdraw which petition?
This particular petition, now number 001 of 2024, the Jared Mairura petition. So that my proposal for order, let us deal with that petition first as it is, considering most of us are still not parties. So that let the substantive parties deal with the issues first. Then, depending with the court's direction, then we'll see if we are coming in or if there is need even for us to be parties to that particular file. That's all, Melody.
My lady, or our party disagree.
My lady, could we also be given an opportunity to speak before Mr. Kato speaks?
We are just doing housekeeping for now. It seems like parties cannot agree on which matter they are dealing with first. Maybe I will just go back to my chambers and you agree. I am with file number 1, Nyamira number 1 of 2024, Jared Mairura Ratemo versus the Senate.
Yes, that's the file. That is the file.
That is the file that is before you, and the orders of Justice Ogola was that the 4 files are already consolidated. That is order number 2 of Justice Ogola for the order of 5th April 2024. So I believe it should be handled with all these other files, which is petition number 3 of 2024, petition number 3 KISI, the petition number 3 2024 in KISI, petition number 4 2024 in KISI, and petition 159 of 2024 in Nairobi. The orders of Justice Ogola is that they had been consolidated and they had together to save judicial time.
My Lord, if you can allow me also.
Since you are many counsel on the call and I'm very far from the screen, when you address me virtually, you'll have to introduce yourself again so that I know who is addressing the call.
This is only for the petitioner in 001, 2024.
Yes.
There was an issue before Judge Ogola as to representation between myself and Ms. Karaoke Owesi. That is an issue that ought to be dealt with first before Ms. Owesi makes any submissions as to consolidation and other related matters. The way I understood the order of Judge Ogola on 5th of April is that there is no consolidation at all. The matters were just to be mentioned before you today so that perhaps you can make an order of consolidation. But that notwithstanding, there's an issue between me and Ms. Owesi that needs to be sorted out. Because there's a notice of change I filed in court.
The issue of representation can come after court has made the closing order, and that was
Let
the issue
me-
that was before Justice Ogola.
Miss Karaoke, Miss Karaoke,
Yes, my.
please,
Yes,
you'll wait for your colleague to finish his submissions before you jump in.
Most obliged, my lady.
Thank you, my lady, for the protection. My lady, now that issue of representation needs to be addressed first. Because there's a notice of change which I filed, and it's dated 28th of March 2024. It's on the court record. That takes away the right of Ms. Owesi to address this court. And if you look at that notice of change, my lady, you'll be able to see that it is endorsed by the petitioner himself at the bottom of the notice of change.
Come again, you filed your notice of change when?
It was filed on 28th of March 2024 and dated on the event date.
Yes.
And it has effectively taken away representation from Ms. Karaoke Owesi, such that now she has no audience at all before this court. And the counsel to handle this matter is myself, my lord. That notice of change has not been disputed. And I refer your lordship to the bottom side of that order, that notice of change, where the petitioner himself has endorsed it. My lord, that once that is done by a party, that is the end of the road for the previous advocate. And she has no audience before this court, as much as it might sound painful, but she has no audience before this court. At the same time, I would happily submit that counsel be excused from these proceedings from now. So that other issues can be addressed before this court.
Are you done?
Maybe to add that, and then just to add that, if there is an issue of that notice of change, it has not been brought before this court. By way of any formal application. Right away, we proceed to the other issues.
My lady, can I address you now?
Yes.
Yes, my lady, that I, pursuant to the instructions of the client, I find the petition before you. With the notice of change. Service on record showing that I have been served with that notice of change. When you were before Justice Ogola, I said I have not been able to trace my client. I'm trying to call him. He has not still gotten back to me. To representation. But apart from the fact that he has a right to representation, pronounce itself on it. There is the issue of this consolidation for you, and there's the issue of withdrawal.
Miss
That is
Kariuki.
fine, that is,
Miss
yes, my lady. And it's the reason as to why before you today, my lady. My lady, this is a public interest. The petition. I believe it's only just that also be heard.
Can I make a short rejoinder?
I don't know if Miss Kariuki was done with her submissions. Okay. Mr.
I
Muni.
believe was
Yes, just a brief rejoinder, my lord. Thank you. My lord, this petition, in as much as it was filed by Mr. Kariuki, the petition belongs to the petitioner himself. We are merely agents for clients. The petition was filed by Jairus Mairura, and he has given instructions that he desires to be represented by another law firm, by another advocate. So the issue of that the petition was filed, that the council filed a petition, cannot hold because the petition is filed by a client who is on record.
Yes.
And his name is known and disclosed. So, my lord, you know that on 5th of April we appeared before Judge Ogola. And council was informed and was aware that there is a notice of change and there is a notice of withdrawal of suit. Those notices are in the court portal. She was informed in court that there is a notice of change, even though she had disputed service of those notices. But she was made aware of the existence of those notices. So she cannot say today she has not been served, while she is very much aware that those notices are in existence. The notice of change, the notice of withdrawal of suits. So it would serve everybody better and in more appropriate ways if council is excused today from these proceedings. Because it is clear from the notice of withdrawal and notice of change that the petitioner has changed the representation. This case belongs to him, not the council. And just as a rider on the other side, the same petitioner is on the way to the court.
Come
He has
again.
not disappeared. The petitioner is on the way. The petitioner is on the way to court. And he informed me that it will take the next 30 minutes or so. He has never disappeared. If he had disappeared, there would be a police record, a police report. By perhaps counsel, Mr. Wesi. He has never disappeared. I've just spoken to him right now. He's on his way to the court premises. And I have the court to act on the notices already filed in court and excuse counsel from the proceedings. That's all.
My lady, just one issue. Being aware of a notice of change existing and the notice of withdrawal is not service. There is a reason as to why there is need for service. And you cannot run away from that.
My lady will pay her costs. The only remedy available to counsel is costs, not forced representation.
My lady, also there is public interest, and at times the behavior of the parties also can come into question.
Yeah, just the mere fact that this matter has been referred to me and I'm hearing it does not mean you break the rules of engagement. Once a council makes an application or submissions, the other council responds, then the other one makes a rejoinder. It ends there. It cannot be a back and forth.
My Lord, the apology.
Yes, so I think the court will have to pronounce itself on the issue of representation if we are to go systematically.
Could I request for your audience, my lady? Thank you.
I don't know, are you on the issue of representation or on another issue?
On the issue, you said, my lady, that you called file number 1.
Yes.
And my question would be, my lady, whether the intention of the court is to say file number 1 is only the file that was originally KC petition number 6, or file number 1 incorporates the 6 files, sorry, the 4 files. What is the meaning of file number 1? Because as I can see, you have that one file, but in it incorporates all the files that Justice Ogola.
You will understand that I was sent a mongrel file.
Yes, ma'am. Yes.
It is a file that it is a cocktail.
Yes, ma'am.
So within this cocktail, an issue has arisen.
Yes, ma'am.
Of representation.
Yes, ma'am.
Yes.
In one of the many items inside, my lady. So, okay, my lady, you said you wanted to take time to reflect on the issues raised.
Yes.
We would just pray that 2 things apply to you, or rather 3. One is whether this file is only 1 file or 4 files. That's one, my lady. The second one is whether there is any doubt that the 4 files were consolidated in the face of order number 2, which says that the following petitions shall be consolidated and be heard together. My lady, is there any doubt as to the meaning of the following petitions shall be consolidated and be heard together, and then the 4 files are listed together? And lastly, my lady, we pray that you look at the order made by the learned judge in Machakos, which were sustained in Nairobi and which are before you. The judge had public interest in mind. It was not a question of whether the petitioner, Mr. Ratemo's car had been stolen. It was not a question of whether he had been assaulted. It was a public interest issue. And my lady, that was what the judge wanted to preserve. And so, if Mr. Ratemo were to have been compromised,
my lady, I think you give direction that we deal with one thing at first, representation. Then we can come to that issue of who represents the application for withdrawal. Is it Ms. Kariuki or my learned friend? So that then Mr. Kato Kigen can then have audience on that particular issue. For what I think the leadership, we need representation determined first.
Okay, the bottom line is this, my lady, that when you are reflecting on that question, the question of who represents who, please take into account that the interest and the basis of the issues of the order was public interest, my lady. And this petition went to the department dealing with public law, my lady. It was not a personal issue. So that if Mr. Mairona has chosen to change representation, my lady do not lose sight of the public interest involved in it.
My lady, if I may address you now.
Just 1 second. And lastly, my lady, is the question of our applications for enjoyment. Yes, thank you, Mr. President. Lastly, my lady, is the question of the enjoinders we have sought, my lady. So many of us have sought to be participating in that petition. It is our view that those applications for enjoinder should be determined first before we now come back to the question of the fight between Mr. Moli and Ms. Kariuki and the question of withdrawal. You would pray that you prioritize the question of agenda.
Maybe with your very kind vision.
Yes, Mr. Ochoki.
My understanding of Justice Ogola's order is that all the matters, the files before you were consolidated. There is absolutely no doubt about that. My proposal, my lady, could have been that we take quorum in all the files as indicated in link 2 of Justice Ogola's order, then decide, because if the petitioner is in petition 1, because I believe now we have only one petition, Nyamira Petition 1, which encompasses Kisii Petition 3 of 24, Nairobi Petition 159 of 24, and Kisii Petition 4 of 24. My proposal, my lady, could have been that rather than you making a determination on an issue in a consolidated petition, we could have taken quorum in all the 4 petitions so that we decide, because I believe then Mr. Maihura, who wishes to withdraw his petition, can be petitioner 1, we can have the petitioner in petition 4 become petitioner 2, and such for ease of the proceedings, and to refer to what Justice Ogola said, to save on judicial time. I believe, my lady, that will save everyone's time, rather than burdening you with having to go and render a decision on representation and coming back, because there are colleagues that are here representing petitioners in these matters as related who have not come on record, my lady.
My lady, with your very kind permission, this is Mr. Dayori.
Yes.
My lady, let me just try to be of assistance to the court in terms of what transpired on the 5th, because I was actually before Justice Ogola as he was making those orders. My lady, there are 2 questions that arose before Justice Ogola. The first was the question of representation, and the second is the issue that has been largely addressed by counsel, an application that was intended to be made by the petitioner. My lady, in fact, we have another date, that should be the 22nd, when the matters are supposed to appear before you. The other matters are supposed to appear before you. So ideally, the only matter that is supposed to be before you is what is now characterized as petition 001 of Nyamira. And the reason why it was referred in that manner is so that the court can then deal with one, the question of representation, and thereafter the application that the petitioner had intended to make. And so, my lady, the approach that you have taken is the approach that was contemplated by all the parties when we appeared before rather the PJ. My lady, the position that was taken in court then, on the 5th, and the position that we intend to take now, is that the applications made by the various parties, including my client for Joyner, is largely predicated on the position as to whether the petition will continue or not, because the petitioner had indicated that they have an intention to withdraw that petition. So, my lady, the fact of consolidation, even if it is there, does not extinguish the petitions as they were. And so therefore you can still isolate the different petitions and deal with them, even if they are consolidated and are being added together. They can be isolated if they are different issues arising, as the issues are arising in this matter, dealt with, and then we can now proceed with the question of whether those petitions can be had together as consolidated. So, my lady, the question here then becomes, once you determine the aspect of representation, it is not touching on the other files. There is no question of representation in, for example, Kisii petition number 3. So the only question for representation is arising in this petition 001. And so, my lady, it makes a lot of sense to isolate that petition, deal with the questions that arise, 1, on representation, and 2, on the application by the petitioner to withdraw the petition in its entirety. And once you deal with that question, then we can then address the order by Justice Ogola to have those matters consolidated and add together. And so, my lady, I just want to urge that you resist the temptation to convolute this matter as you're being urged by parties who are appearing for respondents on the other side, and to whose advantage it would work if this matter is convoluted, and deal with the isolated issue of representation. And already I heard that the petitioner is coming to court. If the petitioner is coming to court, he can be able to settle the issue of representation, say who his advocate is. And then we move to the next question of how we determine the question of withdrawal. If the petition is being withdrawn, our applications fail. If the petition is proceeding, then we make our various applications for joinder. And that, I think, my lady, would be the most efficient way of dealing with this one. Thank you, my lady.
Anybody else wants to
Yes, Your Ladyship, just to
say something? Yes.
Yes, Nego, just to be traced on what my senior friend Mr. Kauri has indicated.
Yes.
That none of us have audience in the matter before you due to the fact that we have not become substantive parties. The only persons who have audience is the two advocates who are contesting on representation, and the Senate, who are parties. Once you make a determination as to who should address you, then the party, the council, who the court shall have determined has audience before you, will urge the application for withdrawal. If it fails, then we urge our applications for joinder. And I think that's the easiest way of navigating through these murky waters that are being created by some interested parties in that matter.
Lady, you asked if anybody has anything to say.
Just a moment, I finish what he has said. I was taking notes. Yes, Mr. Katwa.
My colleague, Mr. Oginga, said he wants to go first in the round. And my lady will realize that we are two camps. He's on the other side. So we could go first with your permission.
So, Mr. Oginga, you go first?
Yes, I'll go first so that our senior can respond. So that, my lady, as you give directions, I think it's orderly because we are still going back to the other files. So that we are not just disposing of the entire file by this ruling on representation. So that the issues that our senior Mr. Keegan is raising, we shall still deal with them after the court gives directions on how we move with this particular file. Then secondly, my lady, we are also trying to save the court's time. So that if the petitioner wants to withdraw this particular petition, then the question of our joinder applications becomes moot. Because it will be a waste of judicial time for us just to join that petition for the purpose of withdrawal. That's all, my lady.
I address you, my lady, just in 1 minute. This is Elias Mutuma.
Yes, Mr. Mutuma.
Yes, my lady, the only reason why it is inevitable for you to make a determination on the issue of representation is if you mention the other matters, there is a likelihood that Ms. Karaoke will make certain amendments that she will want to go on record. Mr. Muli will also want to make certain amendments all purporting to represent the same party. That will be chaotic. So there is no way the court can avoid making that determination, because it will be very unready for the court, because it will be hearing from two advocates having two versions of the petitioner. So I do not think we have any other way other than the court making that determination before we move and vote. Thank you.
Mr. Kigen?
Thank you, my lady. My lady, Mr. Euri, introducing his submission, said that it was a clear intention of the parties and the court that you determine the question of representation first, and the procedure you are done. My lady, I would like to say he was speaking for himself. That's not the position of the rest of us. My lady, the position for the rest of us, for the other side of ourselves, my lady, is whereas Mr. Deuri, Mr. Ndegwa, and Mr. Odinga are saying that if you determine the question of representation, you will avoid conflating the matter, according to Mr. Deuri, that you'll be making the issues easy, according to Mr. Ndegwa, and according to Mr. Mutuma, it is inevitable, my lady, and Mr. Odinga, that it will save court's time. Our position is that you should determine the question of gender first. And the reason why we want you to determine the question of gender before you determine the question of representation is because, my lady, this is a public interest issue. It is not Mr. Atemo's issues that are outside. It is a public interest issue. And so the question of the position of the rest of the parties who want to be enjoined should be taken on board when he now stands up to say, I want to withdraw. So that we all have stakes in his motion to court and the order that the court gave. For that reason, my lady, we pray that as you take time to reflect on it, you retire knowing that there are two competing positions. The position by the public saying that the question of gender should be determined first before the question of representation, and the attendant question of the intention to withdraw the petition, vis-a-vis the position of the other side that the question of representation and withdrawal is determined. We pray, my lady, that you bring those two concerns in mind. Thank you.
My lady, with your kind permission, Kariuki always say, just for the court's appreciation, the orders of the court had been extracted, and the issue that Mr. Deuri is bringing, that there's another date, are not in that order because that date was discharged. So the date that we have before you is 2. And on the issue of change of advocates, I believe it's intertwined with the issue of withdrawal, because there's a notice of change of advocates and immediately there's also, together with a notice of withdrawal. And in that, then the rule 27 of Mutunga rules come in. And so when Senior Katwa is saying that you first of all deal with the issue of enjoinder, then you come back to the issue of withdrawal and representation, then it would make sense for the interest of the public. That will be all for now, Malik.
My lady,
and the order extracted is also in court, so the court is able to appreciate what orders Justice Ogola gave, and the proceedings are also very clear on it.
My Lord, I thought we agreed that there are rules of engagement to be followed. Do I have a right to respond to that also?
Ms. Kariuki is determined to break the rules of engagement, so don't break them yourself. Yes,
sorry, my lady, this is the interest of the court. I'm also an officer of the court. I was in court on 5th, my lady.
At this juncture, the court will take a break.
Thank you.
Senior, what do you call it? Wewe ukaribia chai. Unaangalia hizi, si ndio? Hiyo kitu lazima kwanza itakabiliwe. Ndani na address code on the issues of yes. Senior, tuende ukaribia chai bwana.